everybody, a very warm welcome to thorough newspaper analysis for the 30th of March 2024. Now let's quickly proceed to the agenda for today. So first of all, we have the editorial segment. And here we have an Indian Express article which again discusses the entire matter of conflict between governor and state government over giving assent to bills. Then we talk about the news updates for the day, and this is going to be followed by the last segment of legal news. Now let's quickly head to the article. The title of this article is Kerala government goes to Supreme Court over governor withholding assent to bills, the issues and the law concerned here. Now let's first quickly see the context and understand as to what is the newest development that has happened in this entire tussle. So the Kerala government last week approached the Honorable Supreme Court saying that President of India, Draupadi Murmu, had withheld assent to 4 bills which were passed by the state while disclosing no reasons whatsoever for such withholding of the bills, and that governor of the state, Arif Mohammed Khan, had withheld assent to at least 7 bills, some for as long as 2 years, before the governor referred these bills to the president. Kerala, which is ruled by Left Democratic Front, which is a regional party there, urged the top court to declare the referring of state bills to the president as unconstitutional and lacking in good faith. So what has happened here? Kerala government is before the Supreme Court saying that recently 2 things happened. Firstly, the governor of the state initially withheld his assent for as many as 7 bills and for as long as 2 years, and eventually referred those bills for consideration of the president. And eventually, the president of India, she withheld her, giving assent to those bills, to 4 of those bills, without assigning any reasons for doing so. And therefore, they are saying the Supreme Court should declare her action to be unconstitutional and lacking in good faith. Now, this is the newest chapter in the conflict between states which are ruled by opposition parties and their governors, who are appointed by the president on the centre's advice. Over the past year, multiple states, including Kerala, Tamil Nadu, Telangana, and Punjab, they've approached the Supreme Court about governors withholding assent to bills for long periods of time. Now, let's see what is a governor's role in lawmaking. So see, there is an article in the Constitution of India, which is Article 200. It categorically states that after a bill has been passed by the state legislature, it shall be presented to the governor. The governor then has 3 options. So A, very clear that the governor can give, categorical assent to the bill. So once the governor gives assent, then eventually it becomes a law. Secondly, the governor can withhold assent or reserve the bill for consideration of the president. This is the 3rd option. Now let's talk about, see, 3rd option is also clear that the bill is reserved for consideration of the president. 1st option is also clear. The governor is okaying the bill. He's giving his assent. The problem comes with the 2nd option, withholding assent. Now a question may arise, for how long? When he is withholding, what is to be done? So see, for a situation where assent is withheld, Article 200 states that the governor, he may, as soon as possible after the presentation to him, return the bill together with a message requesting that the house or houses, if there are bicameral legislatures in the state, they will reconsider the bill or any specified provision thereof. And if the bill is passed again by the house or the houses with or without amendment, and they are again presented to the governor for his assent, then the governor shall not withhold assent therefrom. The latter part of the proviso clearly gives the government the final say on enacting the legislations, because once the government or these assemblies pass the bill again, then the governor has to okay it. Now see, since the article, it does not provide a timeline, therefore the governors, they have often withheld assent to bills for extended periods, thereby effectively leaving them and the state legislature in a state of inertia, because no progress is being made, and there's then this tension and conflict. Now let's talk about what is the role of a president in the process of lawmaking. So in situations where a bill is sent to the consideration, to the president for his consideration, which was the third option, the president can either give or withhold his assent. This is dealt with in Article 201 of the Indian Constitution. So if assent is withheld, then the president requests the governor to return the bill to the state legislature for reconsideration. And the state then has a period of 6 months to reconsider the bill. And if that is not done, then it will result in the bill lapsing. Now, here's an interesting and important point. See, governor did not have the final say. The final say was with the state legislature. But here there's a difference. The president has the final say. Why? Because if the bill is passed once again by the state legislature, then it must be sent back to the president who, unlike the governor, is under no obligation to give assent when assessing the reconsidered bill. This is the only situation in which the state governments, they do not have the final say in their own lawmaking process. Now let's talk about what is the issue that has been flagged and raised by the Kerala government. So the Kerala government's petition, it terms the actions of both the governor of the state and the Indian president as manifestly arbitrary. That is an action that is unreasonable, it is irrational, and it is an action which has resulted in violation of right to equality. This was the government's contention. Further, the petition argued that the decision to keep bills pending, it violates Article 200 by not making a decision as soon as possible. As such, the governor had subverted the functioning of the state legislature and rendered its existence itself ineffective. And ineffective and also in such a state that it is not going to serve any sort of practical purpose, the government has said. On President's decision to withhold assent to 4 of the bills which were referred to her, the Kerala government has argued that this was done without giving any reasons whatsoever. This, the government claimed, it is in violation of Article 201. Now, how are they justifying this violation? They're saying that this article states that the president is required to return the bill with a message containing such amendments as the president may want the state legislature to reconsider. Now let's talk about what is the situation in other states. So in November last year, the Supreme Court expressed serious concern at Tamil Nadu Governor R.N. Ravi's decision to withhold assent to 10 bills. This story we've done for a couple of times, and by now I'm sure all of us, are familiar with the legalities of this topic. So what happened last November, Supreme Court expressed very serious concern about the tendency of the governor of the state of Tamil Nadu in not giving assent. So he had withheld assent for at least 10 bills. And some of those bills were passed by the state legislature back in January of 2020, which is about 4 years now. So 3 days later, all the 10 bills, they were returned for reconsideration by the governor of the state legislature with no reasons given for the decision. Tamil Nadu's DMK government and the governor, they have been at loggerheads, which means they've been at conflicting interest for a really long time. Most recently, the Supreme Court criticized the governor for refusing to appoint K. Moody. We've also done this story also, that how the governor has said that, we will not inculcate this person again with a portfolio as a minister. Why? Because he has charges of corruption, and that is a reflection of moral turpitude. So recently, the Supreme Court criticized the governor's action in refusing this appointment as the state's minister for higher education, despite the Supreme Court itself saying his criminal conviction. In its petition to the apex court regarding the governor's alleged overreach, the Tamil Nadu government claimed that Ravi has positioned himself as a political rival to the state government. The Telangana government also approached the Supreme Court in March 2023 over former governor of the states who refused to give assent to 10 bills that were passed by its legislative assembly. And when this matter came before the Supreme Court, then later, shortly after that only, she gave her assent. Nevertheless, senior advocate Dushyant Dave in April still pushed for the court to pass directions in the matter, telling the bench of the Supreme Court that the elected government, it is now at the mercy of the governor. Telangana, it is an opposition state, And so this is happening. At the time, the court refused to pass a detailed order on the subject, but the court did say this, which is that the expression as soon as possible, which is used in Article 200, it has a significant constitutional intent, and therefore it must be borne in mind, it must be considered while the governor, is withholding the assent for a really long time. Because the word as soon as possible, this has some constitutional significance. Now let's talk about the question of timeline for assent. See, in November last year, the Supreme Court was to decide if a governor could withhold assent to bills which are passed by the state legislature if he believed that the session where the bills were passed, they were convened illegally. So this was one of the questions before the Supreme Court. And here, this is how this question stemmed. Because the governor of Punjab, he refused to give assent to 4 bills which were passed by Punjab Assembly. And he stated that I did so because he received some legal advice that led him to believe that the bills, they were passed in breach of law and process or procedure. However, the bills, they were not remitted to the Assembly for reconsideration. So they were just withholding of the bill and no remitting the bill for reconsideration of the State Assembly. So the court held that the governor did not have the power to thwart the normal course of lawmaking by the state legislatures, and held that the phrase as soon as possible, which is used in Article 200, it means that the governor cannot be at liberty to keep the bill pending infinitely without any action whatsoever. If the governor decides to withhold assent, then he is bound to follow the procedure which is provided in the first proviso of Article 200. And what is that procedure? That you return the bill for reconsideration of the state legislature with a message which contains the proposed amendment that the governor would want the assembly to reconsider, or in general, the governor can say, that this is my message, you reconsider the entire bill, or you reconsider these amendments. Though the court spelled out the obligation of the governor in lawmaking process, it stopped short of providing a definitive timeline to the governor to make the decision. The Kerala government has now approached the Supreme Court to address the very same issue. So, let's see what the Supreme Court has to say and how the events are going to unfold and whether we'll be able to arrive at a timeline or not. And so this is going to be interesting for us to see. So now let's proceed to the next segment of national news, with this being the first update. Popular Tamil actor Lakshmi NarayananSeshu, he passes away. Lakshmi NarayananSeshu, a beloved figure in the Tamil entertainment industry, he breathed his last very recently. The versatile actor was 60 years at the time of his death. Let's talk about his filmography. So he was a very versatile actor, very beloved figures, and his filmography, it boasts of several memorable performances, including roles in hit movies like A1, then we have Gulu Gulu, Draupadi, to name a few. Next up is this update. Gujarat State Education Minister, he launches Shiksha reform. Please note who launched. So the state concerned is Gujarat. What is the reform called? It is Shiksha reform. So the Minister of State for Education for Gujarat, he has launched the online learning platform which is called Shiksha Reforms in Surat. This event was attended by noted educationists. Let's talk about some of its key features. So first of all, this was a collaborative effort of the government with Microsoft and a leading Finnish university. It is offering European credits for students. It equips students with vital technological skills, giving a boost to their careers. It is preparing, the courses they are prepared by leading corporations and universities with state-of-art study materials. NTPC, which is the power giant, state-owned power giant, it secures US $200 million loan from JBIC for renewable projects. So state-owned power giant NTPC, it has finalized an agreement with Japan Bank for International Cooperation to obtain foreign currency loans totaling US $200 million. The financing arrangement, it signifies a significant step in NTPC's endeavor to augment its renewable energy initiative. Let's talk about NTPC. So this is formerly called the National Thermal Power Corporation. This is an Indian central public sector undertaking. It is a PSU under the ownership of Ministry of Power and the Government of India. And this is engaged in generation of electricity and other activities. Next up is another important update in the category of appointments. Hansha Mishra is appointed as the director in UPSC. Hansha Mishra, an officer of the Indian Audit and Account Services, has been appointed as the director in the UPSC, which is the Union Public Service Commission. Her appointment comes after she was recommended for central reputation by the Controller and Auditor General of India. Her tenure as the director in the UPSC will be for a period of 5 years or until further orders, whichever is earlier. Next up is the international segment. Here we have an update from Senegal. So Bassirou Diomaye Faye wins Senegal's presidential election. Bassirou Diomaye Faye, an anti-establishment figure, he has won the presidential election of Senegal with a vote share of 54.28% in the first round. 44-year-old, please note, very important, he is set to become Africa's youngest elected president and the first opponent to win in the first round since Senegal's independence from France in 1960. This is something that you may make a note of it, that Senegal got independence from France occupation or rule in 1960. Baltimore bridge collapse. So this is an update on this news story. The largest crane on the eastern US seaboard, it has arrived in Baltimore, which as part of a massive cleanup effort after the Francis Scott Key Bridge collapsed. The port, it is a main economic generator for the state of Maryland and a vital artery for imports and exports of US and of global trade. Next up is an update in the sports and international category. The Melbourne Cricket Ground, it will host a day-night test match between the Australian and English women's cricket teams. This will be the first time that a pink ball test it is played at the iconic venue. The 4-day match it is scheduled from Jan 30 to February 2nd of 2025, which is next year. The day-night test, it is a part of a multi-format Ashes series between Australia and England. And now we head to the legal update segment for today. First is an update from Karnataka High Court. It held that parties who are not signatories to joint venture agreement, they cannot be forced to arbitration proceedings. The Karnataka High Court has held that parties who are not signatories to the joint venture agreement, stipulating the arbitration clause, they cannot be forced into arbitration proceedings. The bench also held that civil court's jurisdiction under Section 9 of the CPC remains intact when there is no arbitration agreement between the litigating parties. Therefore, it held that the joint venture agreement cannot bind other defendants who were not signatories to the agreement. The name of this case is Messrs. MVR Constructions versus Messrs. VMR Constructions and others. Next up is an update from the Supreme Court. The Supreme Court has recently held that a stricter approach regarding bail, it will be adopted regarding cases of custodial torture where police officers are involved. It is a fact that in ordinary circumstances, we ought not to invoke our jurisdiction under Article 136 of the Constitution to invalidate an order granting bail to an accused. But this criteria, while dealing with the question of granting bail, would not apply in a case of custodial death where police officials are arraigned as accused. That is to say, they are made as an accused or they're made as accused. Such alleged offences, they are of grave and serious nature. This is what the Supreme Court said. The name of this case is Ajay Kumar Yadav versus State of UP and others. So this has brought us to an end of TNA. Thank you so much for being with us. Have a wonderful day ahead.